as places where, quote, a courageous state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments without risk to the rest of the country. Now, I bring this up because, and we will get into it in our conversation, the states are the situs of democracy. Given the constitutional structure, states do most of the rulemaking, but as we will see, the Supreme Court intervenes a great deal because of the state's relationship with the federal government and because the Constitution has built into it certain protections for democracy. And yet, even though there is this interplay, states nonetheless have a lot of power. And one of the facts that I want to bring forth in this talk is the fact that states have gone into divergent directions when it's come to the way that election law is administered. We can see this, and we will look at it through the lens of voter access, through the lens, and this leads me to our roadmap here. After giving you a brief background on what this interplay is about, we'll see the divergences and the Supreme Court's influence on these issues around issues of voter access and election integrity, and then gerrymandering, both in terms of partisan gerrymandering and the major case of this past term, Moore v. Harper, and race and gerrymandering, and both the recent case of the last term, Allen v. Milligan, and I'll say a couple of words about a case that was just argued on Wednesday concerning South Carolina's districts. But the idea here is that as laboratories of democracy, states may or may not be laboratories for democracy. And that irony, it seems to me, is built into the Constitution and manifests in these ways. And so I want to explore them. Hopefully, I will do this in about half an hour or so, and then we can use the rest of the hour to have conversation and dialogue around these issues. Although, I have to confess that whenever I say I'm going to do something within a certain amount of time, my students would look at me and go, "Are you sure about that?" So to look at it in perspective, we have to start with the federal Constitution. So there is no guaranteed right to vote in the US Constitution as originally drafted. And usually when I say that, someone in the audience goes, "Oh, but the right to vote's talked about throughout the Constitution." Well, it is implicitly, but there's no definition of what a right to vote means and what individual entitlements an individual citizen ought to have, nor is there any dictate from the Constitution of the United States as to how democracy is supposed to be structured. There are a bunch of caveats that come with the amendments, and we'll talk about those in a little bit. But the 1789 Constitution alludes to voters in the sense of calling them electors who can participate in, as in Article 1, Section 4, Clause 1, the Elections Clause, who can participate in electing members of the House of Representatives. But the Constitution says the people who get to participate in those elections will be the same people who are defined by each individual state as being able to participate in that election. And similarly with the Electors Clause in Article 2 and sort of the prelude to the Electoral College, the same kind of suggestion is made. Now, I usually will talk at length about this topic, but the fact of the matter is, to the extent that the democratic republic that's the United States is built on notions of democracy, those notions are also defined by slavery. And Article 1, Section 2, Clause 3, and other clauses in the Constitution allude to how representation is to be apportioned among the states and how the population is to be counted to include free persons as well as in 3/5 of enslaved persons, the infamous 3/5 compromise. And though it's not the focus of this talk, maybe we'll have a whole other talk about race representation and American democracy, but it's worth noting here that at its core, the 18th century notions of allowing for slavery and tiered personhood, if you will, are written into the Constitution. And part of the story I'm going to tell is one of how this was corrected for and yet is still part of our American struggle today. So it's worth to note where it started. But of course, and forgive the yada yada yada-ing of the first half of the 19th century, where the story of America as a maturing democracy was one that moved from men who owned property who were mostly white being the only allowed voters under state laws in the early 19th century to universal white male suffrage by the mid-19th century, suffrage which was at the expense of permanently excluding black voters. Given that, and how that plus slavery was one of the many things that led to the Civil War, this brings us to Reconstruction. And the Reconstruction amendments both abolish slavery, the 13th Amendment, and the 14th Amendment provides for equal protection of the laws, as well as the notion that the law should protect against rampant disenfranchisement. So Section 2 of the 14th Amendment has a representation stripping penalty clause for states that disenfranchise broad swaths of their population. The idea being that these states ought not to disenfranchise, and therefore there should be a penalty for such. The vision being, well, we don't want to repeat what slavery had done. But then the 15th Amendment explicitly said what the 14th Amendment implied, which is that there would be no discrimination on the basis of race in voting. So in this sense, and of course it is the 15th Amendment which is the first time the phrase the right to vote is articulated in the Constitution, but that comes as a byproduct of all of this democratic striving. In essence, again, the Constitution doesn't explicitly say what guarantees ought to be affirmatively given by the state, but it does guarantee that what the franchise is, whatever that is, should not be judged by racist motives. But of course, the problem is the Jim Crow era is one of working around that guarantee. We had practices in terms of voter access which made the right to vote more and more complicated to exercise. So poll taxes, literacy tests, understanding tests, grandfather clauses, all of these things were rules implemented by the state to prevent the wrong sort of voters who are largely black and largely poor, although it did ironically also prevent poor whites from participating. But certainly the state and private citizens engaged in voter intimidation, right? Threats of violence, and the ultimate sort of violence in the Jim Crow South of lynching. So this problem of violence was inherent in the system. And indeed, even before the Civil War, even before the sort of explicit bars of African Americans from the franchise, there was still this problem of voter intimidation. Scholars of no lower rank than Alexis de Tocqueville documented how even in the North, there was voter intimidation when it came to African Americans in the vote. And as I note here, few if any of these practices were struck down by the courts of the early 20th century because they did not violate the Constitution. In other words, if the courts interpreted these practices as being within the power of the states, and they read the 14th Amendment and 15th Amendment very narrowly. In other words, with a practice like a poll tax, where you had to pay taxes regularly in order to vote, and if you did not pay those taxes, or if you paid them and lost the receipt, and you couldn't present the receipt, you couldn't vote. Even though everybody knew what the motive was, because the law wasn't explicitly about race, the courts of the era said, well, this is still legal because it doesn't explicitly speak to the problem of race. And there is precedent about literacy tests in this regard as well, and the like. Now, another practice that grew up as a product of Jim Crow is gerrymandering as a way of suppressing the vote. Now, I excluded my slide on the origin of the phrase gerrymandering. And it was from Massachusetts in the early 19th century, where the then Eldridge Gerry, member of the Massachusetts government, drew a weird district, and a political cartoonist put a little monster on top of the district and called it the gerrymander, because the district looked like a salamander, but it was Eldridge Gerry, so it's the gerrymander. But I want to bring it up here as part of this theme of American democracy growing out of the problem of race, because I want to talk briefly about Gormillion versus Lightfoot, which, by the way, was argued by distinguished alum of this institution, Fred Gray. Now, Tuskegee, Alabama was roughly a square city under Alabama state law. And here's another theme I'll just signal right now. We'll talk a little bit about Alabama as the lecture goes on. But then you can see on the left, Tuskegee was roughly square, but the state legislature modified the borders of the town so that it reflected more of what was on the right, a 27-sided figure. The folks who lived in the parts that were not shaded, the African American population. The Supreme Court of 1960 recognized Mr. Gray's argument that this violated the 15th Amendment, and the court refused to defer to the states as to their power to draw borders and the like. So this is in and of itself political exclusion. Now, these problems, political exclusion, lack of voter access, distorted representation, many of them were first fixed by the Voting Rights Act of 1965. It's worth noting briefly that the civil rights movement had the right to vote at the heart of its work. And this work culminated on Bloody Sunday in Selma, Alabama in 1965, where Martin King, John Lewis, and others were marching and were attacked by local and state police from Alabama. And this garnered national attention and created the political will that allowed Lyndon B. Johnson to ultimately pass the Voting Rights Act. Now, the act has two major provisions. There is Section 2, which basically restates that 15th Amendment, that there will be no discrimination on voting on the basis of race. And when we talk about Allen v. Milligan, we'll get into Section 2 in more detail. At this point, it's worth noting Section 5, which used to, and we'll talk about why this stopped in a moment, but Section 5, when originally passed, was designed to take those jurisdictions that had a demonstratively bad history when it came to race and voter participation, and lagging gaps between the majority racial group and minority racial groups in terms of participation, to put them under supervision of the federal government. Any voting law change they wanted to pass had to be approved by either a 3-judge court or the U.S. Department of Justice. Now, the modern scheme here also includes recent interventions by Congress, including the National Voter Registration Act of 1993, the so-called Motor Voter Bill, which mandated that states had to provide opportunities to register to vote at all places where the public interfaces with state services, which is why you can register to vote while you're getting your driver's license, for example. And the Help America Vote Act of 2002, which provided for at least the start of some requirements around voter ID, but also built into it certain requirements that states maintain voter registration lists and databases of this sort, how to manage those databases, and other steps that made voting more efficient and effective and maintaining machines and the like. So this creates this scheme around voting for the modern day. And it basically serves as the floor. And now with our Laboratories for Democracy theme, states can go into different directions in terms of how to add to these requirements and how to build upon these laws. But these laws ultimately create the minimum that states have to comply with. Now, the modern era of voting rights law, say within the 20th century, has been one of this structure modulating and states taking different stances in that light. The high watermark of this was the decision in Shelby County versus Holder. Shelby County, Alabama, argued that Section 5 of the Voting Rights Act, that pre-clearance provision, was unconstitutional. And the court, in an opinion by Chief Justice John Roberts, accepted that premise, but did not strike down Section 5. It struck down Section 4B of the act. You can see all these states, the ones colored in red, the entire state was governed by Section 5. The ones in pink had certain jurisdictions within the states governed by Section 5. And these states had introduced restrictive voting laws, which, in light of Section 5, still had to be negotiated by the Department of Justice before they could be implemented. That's the heart of pre-clearance. The court's decision in Shelby County removed that regime by declaring that the formula for choosing which states that ought to be covered was unconstitutional. The court said, well, the formula hasn't kept up with modern times, and it needs to, because by using a formula from the mid-70s in 2013 is, in the court's reasoning, an offense to the equal sovereignty of the states. In other words, the court is saying each state ought to be given deference, and the federal government shouldn't intervene unless there's a good reason to do so. The federal government's reasons haven't kept up with what the states have been doing, and therefore this law has to be thrown out. Now, many people have questioned the grounds of that decision, and we can talk about that in the Q&A because I want to get to this term. But 2013 was a turning point in election law, because after this, many states implemented new election regulations. Notably, at least within the VRA context, North Carolina, Texas, Wisconsin, and others have had, Arizona and Brnovich, all of them faced post-Shelby County litigation in this regard. Yeah, McCrory was about North Carolina intentionally discriminating against African American voters. Beasley v. Abbott was about Texas discriminating against Black and Latino voters. Brnovich was about neutral election regulations that arguably discriminated against Native American voters. We can talk about in the Q&A, but this all just sets the stage for some selected issues that I want to discuss around the following three topics. First, voter access and election integrity. So, Shelby County was a turning point, but there was probably also another important, larger movement in when we're talking about transformations in election law. From the early 90s, there was a great deal of conversation amongst public intellectuals and in certain states about the problem of election integrity, that election integrity was at risk because of the threat of voter fraud. Now, this narrative began with people like Hans von Spakovsky of the Heritage Foundation and other intellectuals who are in the conservative camp. And it motivated first Georgia and then other states and ultimately Indiana to pass voter identification laws on the premise that these laws would protect against voter fraud by ensuring that every voter could be easily identified through a government-issued photographic identification card with the name and address and information about the voter on it. Now, the problem with the narrative, at least in this regard, is that the notion that there is rampant voter impersonation, voter fraud, is dubious. There is virtually no evidence of such fraud, yet the broader narrative, which I will credit, that because this narrative grew into providing for election integrity by building confidence in elections, by building rules that would help bolster public confidence, intertwined with the voter fraud narrative in order to build this view. And of course, voter ID laws and this rationale were given credence in the Supreme Court's decision in 2008 in Crawford versus Marion County Election Board. Now, this was a kickoff point, and certainly in other cases, including a case out of Ohio, and you'll notice I've highlighted important Ohio cases in this regard. This launched the 1,000 ships of election integrity, not just voter ID, but voter purges, and in Hustede versus A. Philip Randolph Institute, the practice of voter purging as Ohio carried it out was endorsed by the US Supreme Court. By voter purging, I mean the practice of taking stale voter registrations and erasing them from the database. That same database that I mentioned was required to be kept by the Help America Vote Act. So if a state suspects that someone's moved away, or if a state thinks that someone has died, or if they do not respond to queries about whether they still live where they live, then the state can remove their voter registration. Ohio has a very short window for that process, and the Supreme Court said that Ohio's window complied with HAVA, the Help America Vote Act. So along with this, there is the growth of stricter requirements for voter registration, including things like, in some states, requiring proof of citizenship requirements to be filled out. In some states, including narrowing windows for registration in relation to the election. And Ohio recently has adopted the longest legally allowable window of 30 days for registering. And then voting itself being made more difficult. And certainly over the years in the 2000s, the growth of practices like early voting, ease of using absentee voting or mail-in voting has grown in some states, but then in other states, including Ohio, the availability of this has narrowed. In fact, let me just get to the Ohio slide. So, as I note, one, Ohio has adopted a strict voter ID law recently. In other words, the only way you can vote in Ohio is to present a government-issued driver's license or a military ID and maybe a couple of other documents, but that's it. This is shrinking what used to be a long list of documents that one could bring in order to identify oneself in order to vote, which advocates against strict voter ID laws argue that this makes voting more difficult because people who, particularly who are poor or who are distracted from being able to work, aren't able to get time off from work to go get the appropriate ID if they don't have it, or to gather the documents, including like requiring a birth certificate in order to obtain an ID or the like. Ohio has also limited the window on which one can request an absentee ballot. You cannot do so online. You have to call or fill out a form and submit the form by mail. And if you use an absentee ballot and mail it in, it has to be postmarked before Election Day, and boards of elections can only count absentee ballots that reach the officials within 4 days of the date of the election. So if the mail is not with you, your vote may not get counted. Now, this stands in contrast with states, and thinking of our neighbor Michigan, which has broader scope in terms of the ability to register, a more flexible voter identification law, and the like. And we'll compare a little bit more later, but this illustrates my story of a tale of two different groups of states that want stricter ID laws and stricter regulation of voter access in the name of preventing voter fraud, and states that want to liberalize access to the ballot. Now, it's also worth noting that in the talk about voter fraud has, in a sense, metastasized into what I have come to call the new election intimidation. In other words, voter fraud has motivated groups of people to, I should say the voter fraud myth has motivated groups of people to attack voters who they believe are fraudulent, poll workers and staffers of elections who they think are in on the fix, and senior election leaders who they blame for what they perceive is a fraudulent process. Now, to call a spade, this is specifically and directly grows out of the rhetoric of former President Trump questioning the results of the elections, as well as questioning election processes, and groups have grown up around this rhetoric and have participated in this kind of intimidation. Now, mind you, as I've suggested earlier, election intimidation, voter intimidation is nothing new, from de Tocqueville to today, but it is a pattern that continues. And it is an irony that we might want to make elections more strict, but we don't, but a number of conservative states don't put in more strict rules that attempt to control the intimidation side of this. Now, being able to vote is one thing. How your vote is structured is another, but it is also part of and parcel of the political process. So we get to apportionment and gerrymandering and representation distortion. Now, I've been teaching election law for 14 years. I found this chart to be the most helpful way to describe gerrymandering. So you can see from the far left, we have a hypothetical group of 50 people. 60% are on team blue, 40% are on team red. And they live contiguously with each other. Now, gerrymandering is about how you draw districts. Each state is required to redraw its districts every 10 years in light of data given to them by the census. They redraw their federal congressional districts. They also redraw state and local districts. So gerrymandering is the art of drawing the lines to distort representation so that it is way out of line with what you would expect in terms of the actual population. So, in the second box, perfect representation. If it's 60% blue, 40% red, if we drew all of the 5 districts around the blue and the red, 10 people each district, then you have perfect representation. Blue wins because blue has 3 districts, red has 2 districts. Perfect representation. Now, you can equally draw a compact district, everything's regularly shaped and not distorted, in a way that outsizes blue's advantage. So instead of drawing the districts vertically, we draw them horizontally. And yes, I had to like think horizontal, vertical. But if we drew them horizontally, we get 5 districts where blue has a 6-4 advantage. Blue wins all 5. Red wins nothing. Blue wins. But it's gerrymandered in that sense. Or if we got creative about how the lines got drawn so that we can create 3 red majority districts and 2 blue majority districts, even though blue is the majority, numerically, red wins because we created districts that are not compact and thus not fair. So even though there's lots of complicated algorithms and what have you, this is the theory of gerrymandering. I can draw districts because I get to direct wherever the line goes in order to capture enough advantage so that I can win the relevant competition. Now, there are various approaches to this. The core idea is one person, one vote, right? Each vote of each citizen ought to weigh equally, which then means that each district should have the same number of people in it so that all of its citizens can have equal weight to their vote. Now, we've explained the process of apportionment already and how that can get distorted by gerrymandering, but the trick is, legally, there are 3 theories of gerrymandering. 1, partisan, so we're trying to imagine our red and blue is political parties, and then there are 2 theories of racial gerrymandering. There's racial vote dilution under Section 2 of the Voting Rights Act, and then there's racial gerrymandering under Shaw v. Reno. And I'll distinguish those 2. And there's my gerrymander. I forgot that I put it here, but there it is. You can see, and this is the impact though. Actually, hang on, let's back it up a second. See, Eldridge Gerry drew the districts as governor of Massachusetts, and political cartoonists criticized it, so they drew a little monster on it. Oh, it's the monster of the gerrymander. But the real impact of this was the extent to which these districts were malapportioned, right? You had one district with 2 state senators who represented 32,000 people, another with 3 state senators representing 37,000 people, and then 5 state senators representing 35,000 people. You know, divide the number of people by senators, you can see that each senator's representation is very different from the other. And Gormillion fits into this realm. We've already talked about it. And in the interest of time, I won't bore you with the sort of legalese of all this, except to say, from the beginning, in a case called Colgrove versus Green, the court rejected the idea that it should weigh in on these issues. It would be going into the political thicket that ought to only be dealt with by the elected branches of government and not the courts. But that view of the court turned with cases like Baker v. Carr in the 60s, Reynolds v. Sims, and we then have the requirement of one person, one vote emerge. And in terms of federal law, each of the 435 representative districts have to be as exactly equal as practicable. When it comes to state representative and legislative districts, slight variation is allowed, but this is one person, one vote. And then Evanwell versus Abbott in 2016 reaffirmed the notion, and it made clear that this is based on total population, not total number of voting age citizens or some other measure. Now, I just want to get to our examples. First of all, partisan gerrymandering, where red and blue is Republican and Democrats. So in North Carolina, we had districts that basically inculcated extreme partisan Republican advantage, where North Carolina is basically a purple state, 50-50 in terms of its electorate, but the North Carolina delegation to Congress is 10 Republicans and 3 Democrats. So, an extreme partisan gerrymander. Now, also Maryland, just so to make the point that it's not just Republicans who do this, partisan gerrymanders as well. These cases were brought up in Ruccio versus Common Cause. And the holding of Ruccio was that partisan gerrymandering is beyond the competence of the federal courts to address. Chief Justice Roberts, in his opinion, looked back at cases like Davis v. Vandermeer and Gill v. Whitford and said, well, the court has been looking for a standard on how to measure this. There simply is not one, he says in Ruccio. And so the federal courts are out of the business. And in this context then, state law nonetheless can have a say around this. So, to make the point, I stressed early on that the federal Constitution does not have specific terms about the right to vote, but 49 out of the 50 states have right to vote provisions in their Constitution, and the 50th has it as a legislative enactment. So every state lays out how one qualifies to vote and how one does vote. And my election law class knows that early on, I make them look at the statutes and say, okay, how does the right to vote work in Ohio? So North Carolina, in Moore v. Harper, was called out for its partisan gerrymander. So back to this heavy advantage. And the difference between this map and the other map is you can see which districts are heavily advantaged for Republicans versus Democrats. So the dark blue is solid Democrat, the light blue is competitive Democrat, solid red, solid Republican, light red, competitive Republican. The North Carolina Constitution has a provision against partisan gerrymandering. The legislature passed this gerrymandered map. The North Carolina Supreme Court struck it down. And the North Carolina State Legislature went to the US Supreme Court, and I have other maps, but I want to get to the text. And they argued, remember we talked about Article 1, Section 4, the Elections Clause early on. They argued that the Elections Clause, by its language, states that it is up to the legislature to draw congressional districts. And they effectively argued that it's the legislature alone of each state that argues, that draws such maps. Now, they made this argument, the Supreme Court in Moore v. Harper rejected it. The opinion, again by Chief Justice Roberts, was one that basically said history, practice, and precedent, none of those support North Carolina's interpretation of the elections clause. Now, there are those like me who have argued that this view that the state legislatures are independent of accountability for the way they draw congressional districts, also known as the independent state legislature theory. This has consequences in terms of mismanaging the balance between federal and state government around these issues. Maybe this also distorts the Republican form of government in a state, because if a court can't weigh in on what a legislature does, then we are effectively mooting a state constitution. And especially in places like North Carolina, race and party strongly correlate. It may have racial consequences. Striking down North Carolina's theory was the correct decision. But I note it here because this is only the most extreme version of the independent state legislature theory. And I think we will see more litigation in the future around these issues on some new version of this theory. Now, I can't let this pass without noting that Ohio just ratified its legislative districts after 6 tries, and that this was based on a bipartisan commission of senior elected officials. But an initiative that likely will make the ballot next year will appoint a citizen commission to do districting if it passes. At this point, the petition needs to get enough signatures in order to pass. But there is a movement afoot to redesign the redistricting process in Ohio. Now, I want to take the last 5 minutes here to talk about gerrymandering and race. Now, I'll note briefly, in fact, we'll come back to Shaw v. Reno. I want to talk first about racial dilution, vote dilution under Section 2 of the Voting Rights Act. So forgive the text, but as we noted, Section 2 of the Voting Rights Act, as amended in 1982, forbids any practice or qualification that diminishes or abridges the opportunity of any citizen to vote on the basis of race. Now, Section B here lays out the test, but I lay this out because this last sentence kicks off the dispute in Allen v. Milligan, that nothing in this section establishes a right to have members of a protected class elected in numbers equal to their proportion in the population. So this was a compromise position in terms of the 1982 amendment to the Voting Rights Act. It's a long history where Congress is responding to what the Supreme Court did in a prior decision called Mobile v. Bolden in 1980, that would arguably have that basically mooted the 15th Amendment as a means to protect the right to vote. But Congress wanted to preserve this through the Voting Rights Act. So Section 2 forbids practices and it moderates gerrymandering. Now, why this last sentence kicks off the dispute? Well, the court, several years later, articulated a test in Thornburg v. Jingles to apply Section 2 to vote dilution claims, so gerrymandering claims. You had to have a minority group sufficient enough to constitute a majority in a single member district. That group had to be politically cohesive, and that group's interests had to be regularly stymied by the majority. Now, this is the test that had gone on from 1986 to today, but in Allen v. Milligan, the state of Alabama argued that its redistricting of its congressional districts, which created only one majority African American district, despite the fact that African Americans were 2/7 of the population of Alabama, was nonetheless in compliance with the Voting Rights Act. Their argument was that they didn't take race into account, and therefore they complied with the Voting Rights Act. And that, moreover, to grant two majority African American districts in this context would run afoul of that last sentence that forbids proportional representation. The Supreme Court rejected this view. And what's probably most important from this opinion is that in the majority, Chief Justice Roberts basically says the Jingles test is still good and we will still follow it. And it requires a race-conscious recognition, right? You have to start from the premise that you can imagine a district where there would be a majority of folks of the relevant minority group. Now, Justice Kavanaugh, in his concurrence, said, this is all well and good, but he was basically kind of saying, this isn't the case today to strike down this rule in the Voting Rights Act, but, talk to me later. And in dissent, Justice Thomas continued to articulate his view that he's had for 30 years, that the Voting Rights Act in its entirety is unconstitutional. And Justice Alito argued that, properly interpreted, Alabama actually ought to win in this context. But the point being the unremarkability of the Allen opinion in terms of its maintaining the Thornburg v. Jingles status quo. Now, because people were shocked that the law didn't change because, given what we talked about earlier in terms of Shelby County v. Holder, most observers, including me, were expecting this to go the other way. But Roberts, Kavanaugh, and the liberals upheld the continuing use of Jingles. Now, in this regard, what's next? Alabama continued to resist the impact of the opinion over the summer, but a 3-judge court ultimately redrew the districts, and those districts will be in effect going forward. There is Allen-type racial vote dilution litigation going on in at least over six other congressional districts across the United States, including in Louisiana, North Carolina, and other places. If these districts are upheld and end up impacting the 2024 election, and given the thin majority in Congress, this decision may help shift that majority. And then, as I noted earlier, in Alexander versus South Carolina NAACP, the court heard arguments on Wednesday over South Carolina's claim that it had actually not violated the law in terms of a different theory around race, racial gerrymandering. So this brings us back to what I skipped earlier. Very quickly, in Shaw v. Reno in 1993, North Carolina drew a very insane district in order to cobble together African American voters on the outskirts of, you see the 12th district basically starts in Durham, goes through the Triad, and ends up on the west side of, or the east side of Charlotte. They drew this crazy district along I-85 in order to do what it viewed as required under the Voting Rights Act to create a 12th majority African American district. Now, the Supreme Court struck down this map by basically saying, well, if you look at this map, you can tell that race predominated the considerations as opposed to other considerations. Contiguousness of the districts, keeping communities of interest together, respecting state and local lines, and the like. Now, South Carolina had its first congressional district struck down under the same principle, that it basically shifted African Americans to the sixth district, represented by Jim Clyburn, in order to maintain the first district as being safe for the Republican incumbent. Their argument was we were simply looking at party, not race. Now, I have written stuff that has basically said, well, given the fact in places like North and South Carolina, the two are inextricable. And if you're dealing with race, then you have to play by the rules regarding race. But according to SCOTUS blog, there seemed to be a majority that was resistant to upholding the district court's decision that sided with the plaintiffs rather than South Carolina. But we'll see what happens in June. And maybe next October, you'll come back and hear me talk about that. Well, we're at the hour. I apologize for I am happy to stay and do Q&A, but I also realize that we've taken up our hour, so if you need to go, but I'm happy to stay for 10 more minutes if you have questions. Yes, sir.
I'm no devotee of gerrymandering, but on a one vote, one voter theory, why not create the state as the district? In other words, we did it once before, where a congressman was elected throughout the entire state. So every voter in the state of Ohio gets to vote. No, there's no discrimination there. If you're eligible to vote, you vote.
So what if, Ohio has how many congressional districts?
Right now, was it 14?
14?
Yeah.
So every voter gets 14 votes?
14 votes, yeah.
And the first 14, right, so, and I mean, this is another way. I mean, it's a whole other lecture, but.
In the 1950s, at that time was referred to as the 23rd district.
Mm-hmm.
The congressman who was elected, but it was a congressional district, 23rd district, and it was elected, in effect, at large. Every person in the state of Ohio got to vote for that.
Right. So this is a multi-member district, right? You could say, we take one, they deserve 14 representatives, everyone gets to vote, first 14 past the post win. Now, in theory, you could do that, but between the Voting Rights Act and other litigation, especially when it comes to congressional districts, the whole notion of a single member district, so one district, one member, is basically the law, right? I mean, in theory, yes, you could take, say, California. California is entitled to 58 members of Congress, right? And you could vote for all 58. But precedent's pretty clear on the notion that, and part of this is sort of textual, right? They read the whole notion of each district gets one representative and they represent a contiguous, finite group of people. Now, if we restructured it at least one advantage would be this. You don't have to worry about how the lines get drawn. You don't have to worry about gaming the map. The disadvantage, and this is where Voting Rights Act litigation, especially Section 5 litigation against multi-member districts, the history has shown that when there is a racial majority and minority involved, the majority basically uses their votes to drown out the minority, and minorities never get elected in multi-member districts. So the courts in the VRA have largely struck down virtually every multi-member district that got brought up in the Section 5 context. Mind you, even if that's not your cup of tea, there's lots of ways to redesign how districts get drawn to ensure representation. In fact, I was at a conference last month whose topic was precisely this. And one way to do it might be ranked choice voting. So yeah, you get 14 votes, but if your preferred number one doesn't get to win, then those votes go to number two, and we work our way through so that a majority of people who prefer that candidate end up getting who they wish, at least
Like
in prior. I'm sorry?
Alaska.
Yeah, like in Alaska. And, or we vote for the party, and the party then decides who represents. So there are a variety of ways. I mean, the theme is, yes, one could get away from the map and thus get away from the gerrymandering games. My gut says I would love to see that, but the trick is, in whatever we do, politicians are crafty and they'll find a way to game the system. Yes, sir.
Will there be Shaw versus Reno challenges for Hispanic population groups or maybe Asian?
Well, there has been for Hispanic populations, right? There's a case, League of Latin American Voters. I forgot who the defendant was at that time, but it's a case out of Texas where they're basically alleging a Shaw theory in the drawing of electoral districts in Texas. So even though a lot of the major Voting Rights Act litigation has been about the black-white binary, it is equally applicable to Latino. I don't know of Asian American representation distortion litigation off the top of my head, but I do certainly know that Latinos have brought these claims and have had success. Yes, sir. And then you, sir. Yes.
Do you see the voting rights and voting rights litigation changing as voting breaks down a little, or racial polarization decreases and educational polarization increases in the U.S.?
Forgive my cynicism, but I think that'll happen when it happens, but I think education, one of my reactions to that is I think education is becoming more stratified, not less these days, and part of this is my thoughts on higher education kind of becoming more expensive and thus more concentrated, and ironically enough, the courts, and this is again a whole other talk, the fact that students for fair admissions versus Harvard, and striking down the use of affirmative action is another sign of further stratification, at least as to elite universities. So, but I do think education beyond universities is important and can help break down some of these barriers. One, voter fraud disinformation is becoming more and more of a destructive force in our democratic process. I wrote a whole paper called Voter Fraud as Epistemic Crisis in American Elections, where I describe some of these things. I think more folks knowing how to consume the internet more critically, who are more educated about the electoral process, that'll help folks vote well and vote better. I also think that, and this is a trend, and I deeply admire Gen Z for sort of questioning the kind of democracy and capitalism interrelationship, which I think has helped sort of realign people's material interests with their political interests. To me, that's the repetition of a pattern that we saw like a century ago in terms of, say, like the Debs movement and movements of that sort, where labor kind of comes at a crisis, and this crisis being the pandemic and the changes that it brought, and that gets people questioning things. The trick is political institutions oftentimes mitigate the questions that get opened up by these crises. And my hope is that it's not just education, but it's advocacy that gets folks rethinking who they should vote for and what they should demand of their elected officials in order to get to better outcomes. Anyway, yes?
So under Rucho, the court says they're not going to look at partisan gerrymandering. That's up to the elected branches. Could it ever become so extreme, I'm thinking Wisconsin, North Carolina, where they can overcome the will of the voters through the partisan gerrymandering? So extreme that it's violating the guarantee of the Republican form of government in the state. If so, how would a party bring that claim?
Okay, maybe this needs to be my next law review article. I could see a world of that sort, right, where the gerrymandering becomes so extreme, especially if it leads to ancillary effects that then diminish the guarantee clause, right? And by the way, those of you who don't know, the guarantee clause basically says the federal government, it's Article 4 of the Constitution, the federal government will guarantee each state a Republican form of government, which most people read as, you know, there's an elected executive, there's a legislature, these people will be elected by the people, and there will be regular elections that are responsive to the will of the people, but it's guaranteed democratic republicanism. I could see a world where the political lockout is so extreme that then someone could argue on the numbers that the party locked out, the election system is basically dead to them. I mean, it might not be a John Roberts world, but down the road, maybe that could get brought. And if so, I would think that, and I mean, I'm just thinking off the top of my head, but sort of envisioning what that harm looks like, because we've seen other examples in history where Texas in the white primary cases come to mind. And the short answer is, where it's so extreme that it's a one-party state where there are ancillary rights of it that get harmed because of the exclusion, then maybe the people excluded can come and say, well, the democratic process is not democratic to us, and therefore we're shut out wrongfully. I mean, this kind of gets in line with like Rick Pildis and others who have written about partisan lockouts and have argued political competition should be the way we should assess things and not race in a kind of civil rights model. But I could see that. Now, just to break down that answer just a little bit, the white primary cases. Texas, back at the turn of the 20th century, passed a law that only white people could vote in the primary for the Democratic Party. The Democratic Party was the only game in town at that time. Black people said, hey, we don't get to weigh in on who gets nominated for the Democratic Party, and so that effectively shuts us out of the right to vote. They sued, they won, and they won on the premise that, well, by shutting out black people from what functions as a governmental process is an equal protection violation, and arguably also violates the 15th Amendment in terms of racial discrimination as well. Texas kept reinventing its primary rules. Okay, black people can vote in the primary, but they can't vote at the nominating convention. Supreme Court struck that down. Texas reinvented it again and said, okay, they can vote at the nominating convention, but we have this super secret committee that figures out who the nominees will be, and only white people can be on that committee. Supreme Court struck that down. The point being, a partisan lockout like that would have to have some kind of ancillary effect through which you can bring that lawsuit, just like with the white primary cases. It's not about the primaries, it's not about the parties, but it's about the racism built into the system. If there is an analog in terms of partisan gerrymandering and extreme forms of it that then give the US Supreme Court some other hook, then maybe that theory could go forward. And I'm glad I recorded that theory. That, like I said, can we work it? By the way, this is Margaret Shaler. She's my research assistant. I want to thank her for her help in putting all this together. So thank you.
And I did also write it down.
And I want to thank you all for staying during stoppage time for this. You saw my email there on the slide, so if you'd like to reach out, feel free. Otherwise, enjoy the rest of the weekend, and I hope you have a good day, and I hope you feel motivated to go help our democracy. Thank you.